Hello, my name is Elizabeth Meneray. I am a Louisiana licensed attorney and one of the principal authors of the Rampart Guide, which was produced as a project of the Ella Project in New Orleans. The goal behind the Rampart Guide is to assist creatives like yourself, primarily musicians, in getting together all of the information that is necessary to create documents that preserve your legacy, identify what body of work you've produced over the course of your life, and allows you to share that with the world, with your family, with your friends, with whomever you choose. The point of the Rampart Guide is to allow you the agency to create a plan so that you know how to share your legacy and to make sure that your wishes are known and carried out the way that you would like to see them. So this video involves will preparation. And in Louisiana, there are two ways to create a will. One is a very simple way called an holographic will, which simply means that the will is completely written in your own hand and that it's signed and dated by you. And in Louisiana, that is all that is required of a valid will. So that is certainly one way to do it. For people who have more property, more family, a larger legacy to share, you may want to go to a lawyer and have a will prepared, in which case the formalities for that will are going to be a little bit more involved. And in the Rampart Guide at page 39, we have a checklist that you can use to prepare yourself to see an attorney to prepare a will. Now you'll see here on the first page that we suggest that you write down your full legal name. Certainly you would also want to include any aliases, any names that you used in a professional capacity, so that you can be properly identified. You'll want to include your address where you live now, including the parish where you reside, and include your date of birth and your gender. Next, we have, that didn't work. We'll go back to page 39. Next, we have your marital status. Now, it's important to identify, your current marital status and identify your current spouse. Unless you are divorced or your spouse has predeceased you, they have rights under our community property laws that you need to be aware of. Simply failing to acknowledge these people does not mean that they don't have rights to inherit from you. However, creating a will is the perfect way to establish what you can and want to do with your property and your legacy. So you'll see here that it indicates, or that you can indicate whether you're married just once and your spouse is living, and down here who that spouse is. If you've been previously married, then either on the back of this page or on a separate piece of paper, you're going to want to write each spouse's name, when and where you were married, and how that marriage ended, either by death or divorce. And you're going to want to make sure that you have certified copies of those judgments of divorce. And that may take some time to get, but you can obtain those through through the court where the divorce was performed. And so you'll also want to include their addresses and contact information in your preparations. Another important thing would be to identify your children. If you have children who are either your biological children or were adopted by you through a court order, then you're going to want to list them here and note their birth dates and whether they were born to you or adopted by you. If you have stepchildren or other people that you want to inherit from you, you would not include them in this section. There's a section below that for this. And those people, stepchildren and other family members do not necessarily have an automatic right to inherit. And so you'll want to specifically name them in your will if you want them included in your estate. All right, moving on to the next page. You'll see that there's a little explanation about something called a usufruct. If you are married in Louisiana and you die while still married, only one half of the property that you accumulated during the marriage belongs to you. The other half belongs to your spouse. And when you die, the use of your half of that community property by law goes to your spouse, and that right exists with them either for the rest of their lives or until they remarry. And if you want something other than what the law already provides, then this is the section where you would say, I'm okay with my spouse having a usufruct over the community property and for her entire life, or just until she or he remarries, in which case I would want that usufruct to end. Now, I should also say that usufruct is not only a right of use, but it's the right to collect the fruits of community property. Fruits of community property mean income. So if you have rental property or investments that collect interest, anything that is created by a piece of property in the form of a profit, say, then the person with usufruct would have the use of the thing as well as the fruits that it produces. Moving on to the next section, you'll be asked to consider who you would want to carry out the wishes of your will. And I'm stumbling here to find that section. Here we go. Under number 4, executor. An executor is the person that you choose to carry out the wishes of for your estate. If it's a female, it's called an executrix. This is usually someone who is very close to you, who you trust completely. It can be your spouse, it can be a close friend or relative. And so you would put their name here. And you'll see the next section asks whether you would want someone else to act in case your executor couldn't act. And I would highly suggest that you have someone noted in your will to avoid any confusion or misunderstanding. So if your executor is unwilling or unable to serve at that point, then this next person would come in and take the responsibilities over. I did it again. Moving through this document can be a little tricky on our Zoom here. All right. Goodness. Okay. The next section involves tutorship, which involves children under 18. And so you can skip this section if you don't have children and don't plan to have children. But if you do, and they're young enough that you are concerned that you might die before they reach adulthood, then the tutorship provision is where you would name another adult to care for your children in the event that you pass away. Now, if the other parent of that child is still alive, it's presumed that they would take over tutorship of the child, but by all means, make your own wishes known so that if that person is unavailable or unwilling to take the children, you still have someone in place who can be the tutor for your children. The next section involves trusts. Certainly, if you have property in an estate that you want your beneficiaries to be able to use over time, you can create a trust. And you can designate a trustee, which is the person who would be in charge of the trust and be in charge of distributing funds from the trust. And certainly the attorney that you meet with to create your will instruct you about how to form a trust and what the laws regarding trusts are. The next section involves your legacy and to whom you would like to leave your property. And so you'll see there's a question here about your personal property, your household goods and furnishings, personal effects. You can say what you would want to have happen to those things. If you have a specific item, you would make what's called a particular legacy, maybe a piece of jewelry or a special piece of furniture that you want to go to a particular person. Then you would indicate below here a list of those items and to whom you would want to leave them. Below that is a section regarding retirement and insurance benefits, which typically fall according to the beneficiary named in the document setting up those plans. And so when you establish, say, an IRA account or you have a pension with your job, you usually will fill out paperwork to designate one or more beneficiaries for that account in the event of your death. Well, your designation in that document actually is the controlling law with regard to those funds. And so those funds pass outside of your will. They don't have the same rules attached to them as other property that you might have. And so you'll want to make a note of what you have in those accounts and who the beneficiaries are. Once you've decided who's going to get these particular things and who your beneficiaries are for insurance and retirement benefits and things of that nature, you may still have property left over, and that's called your residuary estate. And so you will also want to include the name or names of people that you want to get anything extra that you may have once everything is distributed, once bills are paid and that sort of thing. And so you can either leave that all to one person or you can leave it in to several people, depending on your desire. And you'll see here that you can write those names down. Now, I should mention that the PDF of the Rampart Guide that's included on the Ella Project website, this is a fillable document. So you can go into the document like this and type in the name of a person that you want to receive your residuary estate. In this case, you could say, I want 100%. to go to Elizabeth Meneray, or maybe 50% with someone else. And so I just wanted to demonstrate that for you, that that's possible. And you can also say, that you just want anything extra to go to your descendants in equal shares. That's certainly fine as well. Let's see. This next section, if I can get to it, has to do with contingent residuaries. So you may have to name people to take the place, essentially, of a beneficiary in the event that that beneficiary is not alive when it's time to distribute the proceeds of your estate, in which case you can say that these are sort of the secondary beneficiaries. And that is the general overview of the types of information that an attorney will want from you when you go in to consult with them about making a will. You may very well be presented with one of their forms. The law firm may have their own form, and certainly it'll contain a lot of this same information. So, just do what the attorney tells you to do, but definitely go into the meeting prepared with an understanding of what you have, who you want to share it with, and what it is that you want to do with your legacy. Best of luck to you. I hope you enjoy the Rampart Guide. I hope it's of help to you. It's been my pleasure to share this information with you today.